Well, I want to thank y'all for joining us in person and online for our penultimate event for November for Native American Heritage Month. And since this is our 20th year of doing programming surrounding Native American studies, we kind of want to look back and bring back maybe a couple of speakers from previous programs. And one of the first names that came to mind was Jay Bender. Because in 1993, after a lengthy legal battle, the Catawba Nation regained their federal recognition status, meaning that the U.S. government, who had taken away their recognition a few decades earlier, re-recognized them or reaffirmed that the Catawba Nation was a sovereign nation within the United States. Pivotal to this success, though, was the work of attorney Jay Bender. Jay went on to continue his career as an attorney, became a professor at his alma mater, USC, where he started his interest in journalism and eventually led him to become the attorney for the South Carolina Press Association, who gave him their first Lifetime Achievement Award. And Jay Bender continues today as an attorney with the firm Baker, Ravenel, and Bender, and we are delighted to have him here today. So please welcome Jay Bender.
Thank you very much. Nachideha. Yapeiswa. For those of you who speak Catawba and have more language than I do, you can respond. But I played a very minor role in the litigation to restore the tribe to federal status and with respect to the land claim, but it's something of which I'm immensely proud. I served as an attorney for the tribe from 1975 until I went to teach full-time at the university in 2006. I made many great friends and became a better lawyer because of that work. But what we're here today to talk about is a crime story. And like all crime stories, it has lies, fraud, theft, abuse of government power, and some heroes. Where does it start? And like all good stories, it has a beginning, a middle, and an end. Where does it start? When the Europeans showed up on this continent, probably by mistake, they thought they were going to India. They brought with them a secret weapon, smallpox. They also brought with them guns. And they also brought with them a notion that seems absurd on its face, that the King of England could grant ownership of a vast territory that became known as the Carolinas to 6 lords proprietors. Well, the King of England did not own the property, but he created a gift to the lords proprietors. And lo and behold, in this land that was granted to the Lord's proprietor, there were organized societies of indigenous people. And how did the King of England deal with indigenous people? The same way that the King of England dealt with other sovereign nations in Europe, by treaty. Now, there were 2 treaties that were fundamental to the tribe's land claim, one in 1760 and one in 1763, between the Crown and the Catawba people. And it created a reservation of 144,000 acres in the tribe's indigenous territory, which stretched from about the middle of North Carolina along the Catawba River down to what is now Camden. But European settlers encroached upon the tribe. And the Crown, because it wanted the Catawba people to be on the northwest frontier of the British settlements, as to interpose the Catawba between the British settlers and the Cherokee, the British became allied with the Catawba. And this 1760 and 1763 treaty language created this reservation. Now, if you take a look at a map of South Carolina, you will notice where I-77 crosses into North Carolina, there are a couple of straight lines and a couple of right angles. And you might say, what in the world is that about? 144,000 acres is 15 miles on a side. And those two lines are part of the 1760 and 1763 reservation. But in a parallel to today's society, white people who are favored by the government understand that the rules do not apply to them, and the European settlers continued to encroach upon the Catawba territory. Weakened by disease and outnumbered and outgunned by the Europeans, tribal members entered into leases with the European encroachers. And in 1840, another key part of the crime story here, the state of South Carolina entered into a treaty with the Catawba tribe to relocate the tribe in exchange for the 144,000 acre reservation, which the state of South Carolina converted to fee simple ownership for the people who had leases with the Catawba people. Now, because South Carolina is South Carolina and has never understood that rules apply to it, it ignored completely the Indian Non-Intercourse Act, one of the first acts passed by Congress, the Continental Congress, even before the formation of the United States. And it required the transfer of land owned by Indians tribes to have the approval of Congress. Well, since when has South Carolina ever thought it was appropriate to get the approval of Congress for anything? So that's where the theft occurred, and here's where the lie occurred. As part of that treaty in 1840, the state of South Carolina said it would relocate the Catawba people to Haywood County, North Carolina. If you've ever been to Haywood County, North Carolina, you know that that was in the Cherokee territory. And our crime story continues with genocide and racism. Starting in the late 1830s, a genocidal president named Andrew Jackson, who may or may not have been born in South Carolina, depends which side of the line you're on and whether you wish to claim him or not, had relocated every indigenous person he could find east of the Mississippi and walked them to Oklahoma on the Trail of Tears. So the lie was that the Catawba people would be settled in western North Carolina, which had just eliminated every Cherokee who could be found. So the tribal members, and there weren't many left by this time because of that secret weapon, smallpox. And the tribal people petitioned the state of South Carolina for relief when it became clear they would not be settled in western North Carolina. So magnanimously, and this is where fraud continues, the fraud was the promise of land in North Carolina, but the fraud continued because the state of South Carolina bought a 600-acre farm in the middle of the 144,000-acre reservation that had been stolen from the tribe and located the tribe there as a reservation. Move forward to the Great Depression. The United States government, as the country came out of the Depression, recognized that there were people who were starving in the South, people who had no resources. And surprisingly, the United States identified indigenous people as being handicapped by federal Indian policy and by the fact that they had no resources. So the United States government bought about 2,000 acres surrounding the 600 acres that the state had magnanimously given the tribe in exchange for the 144,000 acres it stole, and allowed the Catawba people to live on those 2,000 acres. Well, there was a problem with the federal government owning the 2,000 acres. The people who lived on that land did not have title and could not get a mortgage to build a home. So and during this whole time, leaders of the Catawba Indian Nation continued to press the United States as the trustee for natives under the earliest decisions of the United States Supreme Court and under the Indian Non-Intercourse Act for a return of the 144,000 acres. In the late 1950s, because there was pressure to allow the Catawba tribe members to get land in their own name so they could get mortgages, and because it was federal Indian policy in the Eisenhower administration to end the trust relationship with every tribe that it could possibly end the trust relationship with, Congressman Robert Hemphill from Chester introduced legislation that he assured the tribe would not terminate their federal status, but would allow for the distribution of the 2,000 acres to allow tribal members to get money from that property. During the whole time, Catawba leaders pushed for restoration of the federal trust relationship so that tribal members could benefit from services provided to other tribes. You may have heard of the American Indian Movement, a group of militant tribal people, principally from out west. They occupied the office of the Bureau of Indian Affairs in suburban Washington. And while they were in there, they went through the BIA files, and they discovered that contrary to what Congressman Hemphill was telling the tribe, the 1959 legislation was to terminate their federal trust relationship. And BIA officials had objected to that legislation. But in spite of the objection, Hemphill pushed forward and it passed because it was federal Indian policy to terminate the federal trust relationship with tribes so that the theft of land from natives could be made complete. The American Indian Movement copied the documents in the BIA file because every crime story has to have a good guy. And these folks showed up, according to Catawba legend, in the middle of the night with a footlocker full of files, and they said, you might want to look at this. We think it implicates the federal government in the theft of your land. And the tribe leaders began to look at the documents. And not long after that, there was a group headquartered in Boulder, Colorado, called the Native American Rights Fund, NARF, which set out to help Eastern Indian tribes with their land claims. Because tribes west of the Mississippi are in an entirely different status, because the land west of the Mississippi after the formation of the United States was all federal land. But Eastern tribes were in a different status because they had, as the Catawba did in 1760 and 1763, land title through a treaty. NARF sent Dan Israel and Don Miller to South Carolina to meet with Catawba leaders as part of NARF's program to help Eastern tribes with their land claims. And as they met, the tribal leaders said, we have some documents here that we think relates to our land claim. Because the tribe believed from 1840 forward that its land claim for the 144,000 acres was not extinguished by any illegal act by the state of South Carolina. That's persistence and perseverance. Well, Israel and Miller and others evaluated the tribe's situation and enlisted a local lawyer, Gene Toll, because Gene Toll had civil rights litigation experience, to help with pressing forward with the claim against the state of South Carolina. I had the good fortune of being a very new lawyer and was Toll's associate. So I came along from the beginning. I was with Toll the first time she met with tribal leaders at the old schoolhouse on the reservation. There was a hole in the roof and there was a hole in the floor because there was no money to repair the building. And we started working with NARF in connection with this land claim. How do you redress a historic theft? Now, Gilbert Blue, who was chief of the Catawba tribe and one of the heroes in this story, was asked by a white citizen in the claim area, which included Rock Hill, Fort Mill, Tega Cay, parts of Lancaster, and parts of Chester County. If my grandfather stole a horse, am I still responsible to you for the theft of that horse? And Gilbert's response is, yes, if you're still riding the horse. And the people who were living on the 144,000 acres had benefited from the theft by the state of South Carolina in 1840. They were still riding the horse. Now, I think it might be an entirely different world pressing this settlement claim today, or the land claim today, because the state of South Carolina has decided that any Yahoo who wants to can carry a gun almost any place except inside the state house. And we had concern pushing the land claim that there might be violence because people who were living on the stolen land somehow thought it was theirs and they had a right to continue to ride that horse. And the nerve of these Indians, and this is where the racism comes in, the nerve of these Indians to think they were entitled to get this land back. We tried to settle the claim initially before litigation was filed. A group of lawyers in this area met to discuss how serious the claim was, because if the tribe was right, every land title in the 144,000 acres, except the 2,000 acres sold by the federal government, would be subject to a claim. And if you had written a title opinion that says you have clear title to this property, you were wrong. So these lawyers had a great interest in diminishing and defending against the tribe's claim. And they met and they said, you know, if we settle this case, we won't make any money. So they resisted vigorously. And as a consequence, the state of South Carolina resisted vigorously. The title insurance companies who had written insurance on all the land titles here resisted vigorously. And we tried to settle the case. Now, I mentioned racism. Part of the problem was Dan McLeod, who was the Attorney General at the time, was an old school racist in South Carolina. He did not believe that Indians could possibly have rights. He thought that the tribe, if it got a return of its land and an enhanced reservation, would have whorehouses. It would have bars. Now, what Dan did not know was that the tribal leadership at the time was almost exclusively Mormon. They did not drink and they did not promote prostitution. They left that for the white guys over at the Sunset Lodge in Florence, I've been told. So what do you do when you're up against a government that is opposed to you? You resort to the courts. So the tribe did. Now, who is going to be a defendant in this case? The people on the 144,000 acres, the state of South Carolina, and the United States, because the United States had breached its trust relationship to protect the tribe. Well, how do you identify the people who are on this land? We had the survey from the 1760 reservation, and we had a very good surveyor named Gene Dinkins from Columbia. And we said, Gene, we think we can figure out who the defendant should be if we take this survey and trace it over contemporary tax maps. Because there's a parcel number on each of these pieces, so we would know who was listed on the title. So Gene took that survey from 1760 and he plotted it on contemporary tax maps, and he came back to us and he said, I think I've worked it out within a distance of 5 feet. And I said, 5 feet over what? He said, over a 15-mile side. So we had about 4,200 defendants identified from that technique. Don Miller and I used to have to sneak in to the Register of Deeds offices in Lancaster, Chester, and York to try to identify and cross-reference this stuff we had, because we were concerned if it became known who we were and what we were doing, we might be at risk. I would go in with a fake beard and a wig today if I were going, and maybe paint my face so they wouldn't, well, I don't know, that might make me more of a target. But at any rate, we identified 4,200 defendants. The technical legal term for that, and we had it printed. And the summons is 1 page. The complaint is 3 pages of recitation of legal theory on why the tribe is entitled to the land back that was stolen by the state of South Carolina in 1840. I told you it was a crime story. The list of defendants copied was that thick. Every time I showed that document to anybody, the first thing they did was flip through there to see if their name was in it, because they knew they would be a defendant. And when you file a suit relative to real property, you file what's known as a lis pendens that gives the world notice that this property is subject to litigation. The state statute says a clerk of court must file a lis pendens for $5. So I walked into the clerk of court's office in York. I said, here's our lis pendens, file this. And you could see the dollar signs going around in the treasurer's and the clerk of court's head. $5 a name times, 4,000 defendants, we're going to have the bonuses. I said, no, it says $5 per lis pendens. This is 1 lis pendens. You just have to cross-reference it 4,000 times, which got their attention. We were so concerned about how many documents that we would have generated in this case, and this was in early days of computers, we went to the U.S. District Court clerk's office, and the clerk's office got a grant from the court administration for $100,000 to set up a document processing mechanism in the clerk of court's office. We ultimately ended up settling the case, thanks to a couple of other people who were heroes. I mentioned Gilbert Blue as a hero. His colleagues on the executive committee were heroes because they kept the tribe together. There were people in the tribe who didn't want to engage in this litigation. They wanted to take a buyout. Give us some money, we'll go away. Now, there was a derogatory term for those people. Those people who did not want to preserve the culture of the tribe, didn't want to have a homeland for the tribe, the people who had a vision that has come to fruition since this settlement referred to these other people as cash-only Indians. And fortunately, the tribe got together and settled on a mechanism to resolve this case. And it involved primarily the restoration of federal trust status, which would put the federal government between the tribe and the state of South Carolina, for better or worse. It failed in 1840, and what were the odds that it would continue to help? It failed in 1959. But the trust relationship benefits the tribe in that it opens up access to health programs, housing programs, and educational programs, all essential to the maintenance of a tribal identity and a tribal culture. The settlement also included, thanks to another hero, Crawford Clarkson, who was the state's chief negotiator. Crawford was the head of the South Carolina Department of Revenue, probably the only guy in the history of the state of South Carolina, besides a state auditor, who has ever read the state's annual report. And he looked at it and he said, you know, we have these enormous unfunded liabilities, pension liability, and this Indian claim. He said, I don't know anything about this Indian claim, but he did know me. And he called and said, can you tell me about this? And I explained it to him, probably in somewhat more polite terms than I'm talking now about theft, fraud, chicanery, racism, and genocide. But he said, holy cow, if you guys win, the state of South Carolina is bankrupt. I said, you're talking financially. We agree that it's already morally bankrupt. And he became the state's chief negotiator, which is astonishing given who the governor was, Carroll Campbell. Carroll Campbell didn't care a whit about the tribe or the tribe settlement, even though he has Rock Hill relatives. And he proved that by sending his lawyer along as one of the negotiating teams. And this fellow, Mark Elam, never said a word when we were having a plenary session negotiating. But then he would go back into the breakout session with the state's negotiators and say, hell no, we can't settle this case. We're not going to help these Indians out. And then he tried to insert language that would determine who would be a tribal member. Well, tribes are very serious about determining who is going to be a member of their tribe, and they didn't want some white boy from Columbia in service to racism deciding who was going to be a Catawba Indian. So the other hero is John Spratt. And this is ironic because one of the first Europeans to encroach upon the Catawbas in the 1840 reservation was one of Spratt's ancestors. But John rose above his raisin and got the legislation through Congress. He performed one of the most magnificent feats of historic presentation I have ever seen. We were at a subcommittee in the House of Representatives, and John was there to speak on behalf of the legislation which he had sponsored. And without a single note he traced the history of the Catawba people from the beginning of time through the theft, through the hardship, through the 1959 legislation to this litigation and the potential for settlement. And thanks to him, Congress passed settlement legislation. It had restoration, it had trust fund creation, and it had some money because some people signed on because they wanted to get some money out of it, which was fine. And the lawyers got some money out of it. We only worked 15 years without a fee, but we got a little bit of money out of it too. But mainly what we got was an opportunity for the Catawba people to have an identity that they could continue and to have a culture that they had worked assiduously to maintain for hundreds of years. And I take great pride in that. And Saturday is the Catawba Yapye Iswa Festival down at the Res. I encourage you to go. Look around here and look at this pottery. One of the elements of the settlement was that there is no sales tax on Catawba pottery. And it was to promote potters to develop their wares and sell them. So we have a beginning. We have a middle. That's where we are now. We're past the land claim. I don't know where the end is because there is still substantial impediment to the tribe. And it comes primarily from the state of South Carolina. Crawford Clarkson realized that there were phony charity bingos in the state of South Carolina, and he wanted to eliminate those operators. And he thought a mechanism would be to have Catawba have the premier bingo license in the state. And it took some persuasion, but the tribe agreed to have a special bingo license. It offered bigger prizes, it had better games, and it was designed to put these phony charity bingo operations out of business. So what was the state of South Carolina's response to this? The General Assembly helped these phony charity bingos close the competitive gap. The state of South Carolina remained silent when the city of North Myrtle Beach denied Catawba the opportunity to locate a bingo hall there. The state of South Carolina had an opportunity to have a Catawba gaming facility at the intersection of I-26 and I-95. It had the approval of all local government officials. It had the approval of the entire congressional delegation, Republican and Democrat. But it had one opponent, Governor Mark Sanford, noted adulterer, told me to my face that he was opposed to it because of morality. His standard of morality differs significantly from mine. He got the federal legislation killed by getting his friend John Ensign, who was a senator from Nevada, to hold up the legislation in the Senate until the session ended. Ensign is also an adulterer, and his family owns casinos in Nevada. So, of course, he was doing this on moral grounds at Marky Mark's request. How else has the state of South Carolina interfered with the Catawba Nation in this middle section we're in? Mercedes-Benz wanted to build an automobile factory in the United States. The major shareholder of Mercedes-Benz is the German bank Deutsche Bank. Deutsche Bank reached out to the tribe to say, we understand if we build an automobile plant on tribal land, there are significant tax benefits. And we would like to work with you to get this done. So we set out to set the stage to get this done. There was land that would be transferred to the tribe to be taken in trust down near I-77 and 901 because there was a railroad track that went through there. Now, my guess is it was the Lancaster to Chester Railroad owned by the Close family, which is why they were interested in donating the land. But don't look a gift railroad in the mouth. So we put together a package. Deutsche Bank was extremely interested. And we went down to the Commerce Department. Assistant Chief Evans, Buck George, and I went down there, and we met with the South Carolina Department of Commerce. And we said, here's the deal. Deutsche Bank and Mercedes want to build an automobile factory in tribal land. The response was, Governor Campbell promised the people of Charleston that the next automobile factory coming to South Carolina would be located in Charleston. So we're not going to help you get a Mercedes plant on tribal land in York County. Did Mercedes build an automobile plant in the United States? Yes, you can see it as you drive I-20 west into Georgia. It's that big assembly plant on the south side of I-20. The Carolina Panthers, or as I call them, the Charlotte Panthers, so as not to have any identity with them. I understand they might have won a football game recently. I don't know that, but I have a friend who says that her tickets have become so valuable she can't even give them away. Charlotte was looking to build a football stadium, and Catawba made a pitch, put the stadium on tribal land, and we can get you some tax benefits. We can do this and get you, in exchange, we would like some agreement to employ tribal people. We would like some agreement about concessions. Well, you know, we can't have a football stadium on tribal lands, even though we have a football team known as the Washington Redskins at the time. That football stadium is in downtown Charlotte and was never serious. The Catawba site was never seriously considered, I don't think. Is it racism? I don't know. I can't say. But it might be. It might just be stupidity. But the problem I see is a contemporary problem. If you are a white person favored by the government, the rules do not apply to you. And we can trace that back to 1763, when the Europeans, with the support of the colonial government, encroached on the tribe. We can trace it to 1840, when the state of South Carolina converted the encroachment into fee simple title for the white people who were on the land. We can see it with Dan McLeod's opposition. Where do we go from here? The Catawba gaming facility that is now being built in North Carolina is precisely the one that would have gone at I-26 and 995, but for Marky Mark Sanford's moral objection. And now, lo and behold, a white guy wants to build a gaming casino on the same location, and the white people running South Carolina are falling all over themselves to make it happen. So I don't know where this story ends, but I admire the persistence the dedication, the perseverance of the Catawba people. They have faced extinction. They have survived opposition by the federal government. They have survived opposition by the state government. They have survived opposition by local governments. Can you imagine? Charlotte wanted to have a sewer plant, and it wanted to run the outfall line across tribal land. Now, do you think if it were running across a white subdivision, that it would have been acceptable? It wasn't acceptable to the tribe. The tribe built a housing project. It entered into a contract with the city of Rock Hill to provide water service and paid in advance for the water meters. And then the city of Rock Hill raised the price on the water meters and said, we're not going to buy an ordinance, and we're not going to install them unless you pay us more money. Now, I thought that was contrary to the constitutional prohibition on legislation impairing the obligation of contract, but much to my surprise, an all-white district judge and an all-white panel on the Fourth Circuit said, no, that law doesn't apply to Indian tribes. So the tribe was extorted by the city of Rock Hill to put in water for its housing. I don't know where the story ends, but I have faith that the Catawba people will survive. The Catawba people will thrive. I was thinking about it today. I'm 81 years old. I started working on Catawba in 1975 when I was 31. I had hair, probably many fewer pounds, but it's been a glorious experience. I've made lifelong friends. And to end on a note that's not related exclusively to my pitch that this is a crime story, or maybe it is, because when you watch a television series, particularly if you watch on BritBox, they only have 6 actors in Britain, and they are in every series. But there were people involved in Catawba litigation who have shown up in the most unusual circumstances post land claim settlement. The title insurance companies were represented by a lawyer from Washington named Jim Quarles. Quarles had a big white handlebar mustache, maybe a little bit like Sam Elliott, the actor. Quarles showed up as one of the lawyers in Watergate. Quarles showed up, if you happen to watch Robert Mueller's presentation of his report, Quarles was sitting behind Mueller. He was on Mueller's team investigating Russian interference in the 2016 election. Michael Ludig. I argued the Catawba case en banc in the Fourth Circuit on remand from the United States Supreme Court. En banc means that all the judges who aren't recused, and all the South Carolina judges were, would hear the case. It's in the big ceremonial courtroom. It's a gorgeous room, chandeliers, emerald green carpet, beautiful bench. And you're back here, and we've got about an hour aside because this is a big deal. And Ludig, this is the second time I argued, Ludig had just been named to the court. He looked like he was 12 years old. You could hardly see him above the bench. But now you see him on television all the time because he is one of the foremost conservative critics of the rise of an authoritarian government in the United States. Arlinda Locklear, a young Lumbee tribal member who was associated with NARF, was recently in the news because the Lumbee have fought for centuries to have a federal status, a federal recognition. And Arlinda made a very impressive presentation to Congress recently. She was much younger when we started back in 1975, but she still looks very nice and was the great lawyer that she was starting in 1975. And then there's a woman you may have heard of, Jean Toll. I was Toll's book carrier in 1975. I always joked that I was hired because I could reach the books on the top shelf. When Miller called looking for a lawyer with civil rights litigation experience, he was in Charleston. I'm not sure who he had been down there talking with, Harmon Durfner probably. And he told me that when he had Toll on the phone, he thought he was talking to a 6-foot tall black woman. He was surprised when he met her. She's about that tall. But she can talk Geechee when the need arises. And it turned out, because this is a small damn world, Don Miller's roommate at the University of Colorado when he was in undergraduate school and I had grown up together in Albuquerque, New Mexico. So I've always thought it interesting that a kid from Albuquerque ends up working on an Eastern tribal land claim. I was born in Hominy, Oklahoma, because that was the big town and it had a hospital. And I was in the governor's conference room negotiating an element of the settlement relating to education. And the BIA had sent down a representative, and his name was George Big Eagle. You know, white people say, "Where are you from?" To tribal people, you say, "What's your tribe?" And he said, "Osage." I said, "Yeah, I was born in Osage County." He said, "Where?" I said, "Hominy." He said, "I'm from Hominy." And we laughed that two old boys from Hominy, Oklahoma, were in the office of the governor of South Carolina trying to hammer out a partial solution to a crime that occurred in 1840. So I don't know the end. I'm optimistic. I have a collection of Catawba pottery. Does not challenge this in any way. I told my wife, Ann Cushman, on her way up here, that if I die and she doesn't want the pottery and none of my children want the pottery, send it up here. I have some nice pieces from Earl Robbins, from Sarah and Fox Ayers. So I'd be happy to donate it, but I'm not ready to do it just yet. So that's my presentation. It's a crime story. It has a beginning, a middle, and it's up to us to figure out what the end is. And I will take questions because I get paid on how many questions you ask me.